sorry. Dr. David Clark.
Thank you, Mr. Chair. I rise to speak to the Consumer Law Reform Bill and note from the start that Labor will be supporting this bill through the House. We're looking forward to it passing, and we're wondering why it has taken so long. We're scratching our heads. We're still waiting for that bit of advice from the Attorney General that Mr. Cosgrove sought, and we might be waiting for some time by the look of things. It may be another 4 years before he gets back to us, and who knows how long this bill will languish on the order paper before it makes its way through its stages. There's no doubt that we need strong consumer law in New Zealand. We need protections in place. Mojo Mathers has just referred to the examples of the vacuum cleaner. We've heard other examples earlier in the debate, and there have been several in my local situation that I've heard of recently. The Otago Daily Times was recently reporting in Central Otago a scam involving workmen coming to lay driveway entries and doing incredibly poor workmanship, overcharging and disappearing into the mist. And this is all too common, sadly. In Brockville, in my electorate, Brockville, great suburb in Dunedin North. I invite the member Clayton Cosgrove to come and visit Brockville, a fantastic suburb in the Dunedin North electorate, a very wise suburb that knows how to cast its votes in the right direction. Excellent constituents in that suburb, I would have to say. But one of the unfortunate things that seems to be happening there to one or two families, as was reported to me recently when I attended the opening of the community orchard there, was that payday lenders are making their way into that suburb. They have specific families that they visit, that they pick on, that they wait outside until the family member comes home that they are trying to enforce a debt with. And this kind of behaviour should never be allowed. It's because of slack law in New Zealand. It is because this government has not prioritised consumer protection, and for quite frankly, it's a disgrace. And this is why we on this side of the House, this kind of abuse, the kind of lending that is allowed in New Zealand, that is permitted, the kinds of scamming that goes on, is something that Labour Party stands up very strongly against. It's often those who are most vulnerable, who are picked on, who are at their wits' end, who are caught off guard by a knock at the door when they're trying to manage children, that they're trying to work out where the next dollar's coming from, and they're caught in a vulnerable moment with a product that looks attractive at first blush, sold on that product and then taken advantage of because they don't have the representation that they might have to represent their interests, and the law itself is not strong enough to give them an easy response. I wanted to ask a few questions about the nature of this unconscionable conduct that my colleague Clayton Cosgrove raised. He noted that if unconscionability applies where courts consider it unfair or inequitable or against good conscience to allow a party to enforce its contractual rights against another party who is detrimentally affected by an oppressive bargain, and raised the question really whether and where this might exactly apply. He raised the issue of John Archibald Banks and the ability to apply it in a legal case, and of course didn't discuss the matters about which Mr Banks is appearing before the courts, because that is something that can't be discussed in this House. His previous prosecution can, but not the current one. But I was wondering to what extent this applies. I mean, if a party negotiated a deal where it had itself over a barrel and, for example, negotiated that it would have it purchased a product, negotiated that if the product was to supply a service and that service wasn't delivered properly, but it got rid of all of the comebacks it might have, whether that would be unconscionable conduct and whether it could be enforced. And I guess I'm thinking here of the example of the Sky City deal that's been debated, the casino deal that's been debated often in this House, where the government itself put itself over a barrel and got itself in a situation where only Sky City was the only bidder involved. It made political promises that it felt it must deliver on, and essentially gave Sky City an open cheque, Mr Chair.
Dr. David Clark.
It effectively gave Sky City an open cheque in that it said we will not have any comeback if the facility is not run properly. We won't have any compensation for GDP loss. We won't have any compensation for loss of income tax. We will open up the chequebook if it runs over in the planning stages and looks like it's going to cost a whole lot more. We'll pay for the whole thing off the back of problem gambling, and we will have only 18 jobs for New Zealand as a consequence. Now, that is the Sky City deal, the casino deal this government's done. And is it enforceable in a way that the government can then ask whether it's protected for putting itself in such a stupid position in the first place? Can it then ask whether it's negotiated itself into a position where consumer law ought to protect the government? Now, I don't think it can in the case of this law. I don't think this law is designed to protect governments from their own stupid decisions. But if only it could, that would be a good thing, because this is exactly the kind of thing we see play out on a grand scale. We saw the government give $30 million out to Rio Tinto and got absolutely nothing for it. We would have thought they might have asked for a jobs guarantee or some kind of future certainty. Maybe they got a little tilt in the price of the asset sales deal they were trying to get through as a result of shelling out $30 million to a corporate in New Zealand. Likewise with Sky City, maybe this got the political promise over the line. But again, the government has put taxpayers in such a devastatingly poor position. You've got to wonder whether they have some rights as having put themselves in that position, such that a contract ought not to be able to be applied in good conscience because it's such a bad deal for the Crown. Mr Chair, this bill is making its way through the House, as I've said, incredibly slowly. Inequalities in New Zealand continue to widen. This government has overseen the greatest level of inequality that New Zealand has had since records began. We have tax cuts in 2010 that saw the wealthiest 10% get 40% of the value of those tax cuts, and the most hard up 20% get just 2% of the value of those tax cuts. And that kind of inequality that's gone on is something that this bill is trying to protect against. It is trying to make sure that those who are most vulnerable, Mr Chair, are protected, and we compliment the government for that small measure that's being made here. It seems often so distracted by ideological agendas, asset sales, and the interests of the big end of town. Here we have some consumer law. It is going through very slowly, but at least it is offering some protections for those people. And I petition Mr Goldsmith at the back there to try and do what he can as a now highly ranked Trans-Tasman MP, to make sure that he is also looking out for the little guy. He tells me that Mr Goldsmith at the back there, he tells me that he is very interested in right-wing politics, but I petition him he was John Banks's biographer, and you remind me of the unconscionable conduct earlier, but we're not on hagiography yet, I don't think. Doesn't one? Well, let's not get into that debate. Let's move away from that and come back to the debate. And I petition Mr Goldsmith to do what he can to make sure that markets are fair in New Zealand, not just that markets advantage the big players through unlevel playing fields. This legislation that does make some steps forward for the average consumer is a bill which is really a major win for Consumer New Zealand. Consumer New Zealand in their Consumer magazine highlighted in February last year that delays in consumer reform were really leaving Kiwis a lot worse off than Aussies, who have progressed their legislation much more rapidly. And that petitioning, together with work from Labour, public support from Labour, has meant that this bill has wriggled along a little bit, but we would really strongly implore the people opposite, who sit opposite us in government at this stage, to up the pace. Snail's pace is not good enough for consumer protections. We actually need to get this legislation through and make sure that those who are most vulnerable are protected, that we have sensible laws so that people know when they are investing in a product that it is what it should be, that they have a fair comeback if it's not what it should be or what it claims to be, Mr. Chair.
I'm going to call Andrew Williams.
Thank you, Mr. Chair. I take a call on the consumer law